Okay, we're going to call this hearing to order. We're going to rise to the Pledge of Allegiance. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, first is the introduction of the members of the Electoral Board. By state statute, the Electoral Board consists of myself as mayor, Candace Bilski as clerk, and Trustee Fialco as he is the most senior trustee. But for the purpose of this hearing, Trustee Fialco and Clerk Bilski will be referred to as the members of the Electoral Board, and I will be referred to as chair. We also have Attorney Carroll here, who will take it from here to explain the proceedings for today.
Thank you, Madam Chair. So we are here on behalf of the Municipal Electoral Board of the Village of Homer Glen to address 15 objections to petitions of candidates for the office of trustee for the Village of Homer Glen. As the chair has mentioned, the election code sets forth who is to sit on this board, and it is properly constituted, and all 3 members of the board are present here today. 14 of the objections were filed by one objector, and then there is one additional person that filed a single objection. We have a docket which has been distributed, I believe, to both attorneys. If not, I know Mr. Bassi got one on council. I don't know if you didn't get one, I can give you one. We will call cases in the order in which they're listed on that docket. I did want to address, there you go. Sure. I've been asked by the chair to address a couple of misconceptions that have been circulated throughout social media and otherwise throughout the village, just to let people know how this process works. The Illinois election code contained in the Illinois statutes sets forth what is supposed to happen when an objection to nominating petitions is filed. That objection is filed the same place that petitions are filed, in this case, in the village clerk's office. And once the village clerk is notified of those objections or in receipt of those objections by the Illinois election code, they have to transmit that to the chair of the electoral board by noon the next day. That, in fact, was done, even though noon the next day was election day. And so therefore it could go to Wednesday, but it didn't have to, because the mayor was here and she did receive, as chair of the electoral board, those objections Tuesday morning. The chair then has 24 hours from when she receives the objections to issue what's called a call for hearing, and similar to a notice for a hearing. That's got to be done within 24 hours of when she receives those objections. And that also was done. In fact, on Tuesday, she had already retained me as the attorney for the electoral board, and she had begun reaching out to, in that case, Clerk Bilski and Trustee Fialco. As she mentioned, we're going to call them Member Bilski and Member Fialco during this hearing, to see what their schedule was like, because the law also requires the hearing to be held within 3 to 5 days of the objection being filed. And again, Tuesday being a holiday and next Monday, Veterans Day being a holiday, they could have actually taken it out to Wednesday or Thursday if they had to. That call for hearing went out Wednesday morning within the time allotted by statute. And then the statute requires the chair to attempt service of the objectors, the candidates against whom objections are filed, and the 3 members of the electoral board. It must be done by certified mail and by county sheriff. So people saying that they got an email after the 24 hours, the email is an extra courtesy that the deputy clerk sent out, but the certified letters went out Wednesday, and the Will County Sheriff was tasked with serving those notices or calls for hearing on Wednesday as well. So that's how we are here and why we are here. If you didn't hear me mention before the hearing started, there are appearance forms up here on the dais. Both the attorneys that I'm aware of that are in this case have filed their appearances. If there's any candidate or objector who is not represented by those 2 attorneys, you have to file your own appearance in order to be heard in this matter. And the reason for that is also contained in the election code, and if they're adopted today, the proposed rules and procedures of the Homer Glen Electoral Board. So make sure you come up and get that appearance form if you're not represented by one of the 2 attorneys that have already filed their appearances. With that, I will let the 3 members of the Electoral Board know that the election code also requires them to adopt rules and procedures on the first day they convene, which is now. And so I took the liberty of drafting a proposed set of rules and procedures that are commonly used throughout municipalities all across Illinois. I emailed those to the 3 electoral board members earlier today, and they have copies here in the dais. So, Madam Chair, that's all I have for right now. If there are any amendments or concerns about the rules, I'd be happy to address those. Otherwise, a motion to adopt might be in order. Thank you.
Member Bilski and Member Fialko, have you had a chance to review the rules?
I have not.
Yes, I have. Would you like to take a recess for you to review the rules?
Yes, I would. Of course, you know I was on vacation. I just got home last night flew into Midway at 10 o'clock last night, and I am still, I just got this. Matter of fact, mine was delivered to me this morning. It's 12:53 this morning, the certified mail. With mine, but as far as the rules, I did receive that just now and a little bit earlier, but as far as reviewing every bit of, how many pages are here, Mike?
There's 5 pages.
Okay.
Oh, both sides. If you would like a 5-minute recess to read them, they're pretty standard.
I would.
Okay. Is there a motion
So
to?
if we can have a recess for 10 minutes to do that, that'd be great.
Madam Chair, if we
Sure.
might be able to resolve this as well. For the 2 attorneys that are representing either sides of these 15 petition or objections being filed, have the 2 of you spoken about what your pleasure is today? Are we going to go to substantive hearings today, or do you anticipate asking for a briefing schedule? I'm just trying to help the board decide whether they have to rule on this right now or not.
We'll confer. I think
Would you mind stepping up to the podium?
Yeah, the podium there has a microphone, so it should be on.
Make sure the green button's on.
I'll join you, sir. Thank you. Hi, David Hurst on behalf of the candidates.
And Perry Abbasi on behalf of the objector, who's the same objector in 14 cases, and the candidate in 1 case.
And so, Your Honor, or Counsel, we will certainly confer about what we want to do going forward. I suspect we will go forward today because there are some statutory constraints on time. We have a motion to dismiss that I know the council is familiar with, that we filed. I'd like to present that. And then I'd also like to call an issue to the council's attention just regarding the makeup of the board.
I think those are appropriate for today, and beyond that, to the what's contained in the objections, I think a briefing schedule would be appropriate for either side to have a motion to dismiss and then figure out when we'll have a hearing with, and perhaps request for subpoenas, and when we would set a hearing for all of that.
Madam Chair, so it might be appropriate then to have a recess to allow Member Fialko to review the proposed rules and regulations. Sounds like the counsel for both sides are willing to have their hearing on at least the amended motion to dismiss that was filed today. And then we can have further discussion. I'm assuming they could take advantage of this recess also to confer about what might happen once the motion to dismiss is addressed.
I don't mean to speak for counsel. It sounds like he was requesting a briefing schedule on the motion to
Well, I'm saying you can take the recess that this board's going to take to review the rules, to confer on that, and let us know when we get back.
Will do. Thank
Sound
you.
fair? Madam Chair?
Before we move forward, I'd like to call attention to myself.
Okay.
And my signatures are being questioned out there on a good portion of the candidates that are here today. So with that said, and with my son being one of those to be elected, to be on the ballot to be elected, I almost think, to me, that seems like a conflict of interest, and I should recuse myself. I'd like, between councils to discuss that and tell me where I stand with that.
Madam Chair, or do either side want to be heard on that before I give my opinion to the board?
You may certainly give your opinion. I may have some questions for your board member.
Okay.
No, I think it'd be best if you gave your
Okay.
analysis.
Sure. Madam Chair, may I?
Yes.
So Member Fialko brings up a point about recusals. There's a wide body of case law in Illinois about reasons for recusal for electoral board members. And there are basically two categories, in my opinion, under which it's mandatory for a board member of the electoral board to recuse themselves. The first would be if they're a candidate for the particular election in question. Member Fialco is not a candidate for April's election, and therefore he is not mandatorily forced to recuse himself under that category of case law. The second is when the board member has a financial, or what the law calls pecuniary interest in the proceedings. Sounds complicated, but really what an example of that would be if the thing being challenged instead of a candidate was a referendum. And that referendum was to, let's say, reduce the salary of elected officials. Every one of those elected officials would be conflicted out because that referendum is seeking to reduce their salary. Therefore, they would all have to recuse themselves. What happens if they all recuse themselves? The chief judge of the county appoints members from the public. So beyond that, my reading of the case law, which is fairly voluminous on recusal of electoral board members, those are the only two reasons that jump off a page where the member must recuse themselves. Beyond that, there's ample case law about people being affiliated with the same political party, or they are aligned with a candidate. Those have all been found to be reasons wherein the circuit court typically will not force a candidate, or an electoral board member to remove themselves, or the court will not remove them. So what Member Fialco was talking about is what we as lawyers call appearance of impropriety, which is someone might think I have a bias, therefore I'm going to recuse myself. He's certainly within his right, if he chooses to do that, to do so. He's not one of those members that is mandatorily forced to recuse himself based on what he's saying. Now, there is a little bit of a gray area there. Unlike my understanding of the other two members of this board, as Member Fialco has pointed out, his signature is being challenged. Therefore, depending on what the attorneys do in this case, he may be needed to be called as a witness. If that were to happen, that would be a direct conflict, but it may not be a conflict to all 15 petitions. So I can't give an opinion. I have not reviewed all of the signatures. I have not reviewed all of the petitions. I have reviewed all of the objections, but I can't tell from what I've read how many of those might be a situation where Member Fialco would be a potential witness. So that would be, I think, in my personal and professional opinion, the biggest possible conflict for you, Member Fialco, is your signature requiring you to be a witness. But beyond that, it really comes down to what you're comfortable with.
Okay, because we've got two things in this packet also. We have Pasella against Mueller, and then we also have Carlson against the 14. So I'm guessing that some of them, it would be a conflict for me to be involved, or not a conflict, but they need to recuse myself from someone. Now, the Masella-Mueller one, I don't see why I wouldn't be able to participate in that. But I don't want to waste this court's time with me taking a recess for 10 minutes when I should be recusing myself. In myself, my own opinion, and for my own morals, I think recusing myself at this point is the right path to take, based that my signatures are being questioned on most of the candidates that are in question, and also, you know, the point that my son is one of those seeking to be elected.
Okay. So, Madam Chair, might I take that Member Fialco is recusing himself? Is that?
I am.
Okay. Madam Chair, may I address council here?
Yes.
Okay. So, council, we still have a quorum of the currently constituted electoral board. If you wish, we could discuss the issue of adoption of the proposed rules, because it was Member Fialco who hadn't reviewed them yet, and then we could get to the motion to dismiss as amended this morning, barring any objection to only the two members hearing that. Otherwise, what we could do is take a brief recess. We could reach out to the next most senior, I believe, if I'm not mistaken, and I'll defer to the chair on this, the next two most senior trustees are candidates in the current election, so they would not be eligible to sit. So we would have to call one of the other three in order of seniority trustees to see if they can sit. But what's your pleasure? Are you okay with still the motion to dismiss being ruled on today based on where we're at with this quorum?
You know, on behalf of the candidates, this is an issue I'm going to have to discuss with my clients before I can give you an answer. I'm sorry.
Well, why don't we take a recess? We'll start trying to call some of those other members to see what their availability is. as I mentioned to I think both of you, I have 4 or 5 calls into the Chief Judge's office without a return phone call yet, in the eventuality that we're going to need to get public members appointed. So if you want to take, Madam Chair, a brief recess, counsel can confer with his clients.
I do have one other issue I want to raise, though,
Yes.
before we recess, and that is just the composition of the board. I understand that the board chairman, Miss, and I'm going to pronounce the name wrong, Nordeski, is it Triot?
Knightsky Cherokee, that's okay.
Knightsky Cherokee, thank you.
Yeah.
I apologize for that. And this, certainly with regard to your statements about conflicts of interest, doesn't fall into the mandatory conflict of interest, but it certainly creates an appearance of a potential conflict or impropriety. And that is, so I understanding that this board member publicly endorsed 3 candidates, Rose Reiner, a Nicholas Mueller, and a Mike Laprasi, who are, coincidentally, the 3 candidates that would remain if these objections are granted. So if all 14 of these objections are granted, the 3 remaining candidates would be the ones that were more or less publicly endorsed by the mayor. I think that, in that circumstance, it's not a case where the mayor has maybe one candidate or something that she has a close relationship with. And again, I'm not suggesting that there's, a direct conflict by this, although it certainly creates the appearance if the petitioner's motions are granted with regard to all 14 candidates, the remaining ones are the ones that the mayor has publicly endorsed. So again, we think it'd be appropriate for her to recuse herself under those circumstances.
Madam Chair, would you like my opinion on that?
Yes.
Counsel, as I mentioned, there is a whole host of cases out there that deal with political affiliation, circulating petitions, friends of candidates, et cetera. And each and every one of those has said the only one that can force, there's only 2 ways to force someone off or for someone to be recused forcefully, either by their own act, as Member Fialco just did, or by the circuit court. Beyond that, other than those 2 categories, an appearance of impropriety or political allegiance or alliance has consistently been ruled, but in every case that I read, albeit, as I explained to the chair when we were first starting to constitute this board, the vast majority of case law in Illinois comes out of the 1st District because of how many more elected officials are in Cook County than in other counties. But each and every case I've read stands for the proposition that political alliance or allegiance is not enough for the circuit court to intervene. And again, as with Member Fialco, the chair is certainly within her rights if she wishes to do so voluntarily, but it's my opinion that that's not a basis where she's forced to, or even where the courts would typically intervene in that instance.
And counsel, I understand your statement on this and even respect your opinion. I think this circumstance is a little bit different, though, in that it's outcome determinative. The mayor has identified 3 handpicked candidates that she publicly backs, and that's fine. There's nothing wrong with that. That's not the issue. But again, if the 14 candidates are removed, the outcome of this hearing, in effect, leaves only her 3 slate of individuals left. And so I think that's a little different than perhaps some of the case law that you and I are both accustomed to on recusal.
I understand that, but I have not seen a case that talks about outcome determination, nor the last candidates being left being affiliated with that board member. I'm not aware of a case that says that. In fact, I'm aware of many cases that say that political affiliation is not a sufficient basis for the courts to remove a board member. So that's my recommendation to the chair. She can do with that what she wishes.
So again, we'd call on her to recuse herself.
I'm sorry, I forgot your name, attorney.
It's David Hurst.
David. You're making the assumption that I'm going to remove all 14. I wish you would not assume such a thing. Secondly, the endorsement was made prior to any other petition filing that I was aware of. An endorsement can also come to an additional candidate as well, but I don't foresee myself removing all 14. So no, I'm not recusing myself.
Very well. Thank you for addressing
You're very
that
welcome.
issue. I appreciate it.
Madam Chair, while counsels confer with their clients, I might suggest if the remainder of the board takes a recess for us to at least try to reach out to the next most senior trustee who's eligible to serve, so that by the time they've conferred with their clients, we might have a better idea of when we can impanel a full 3-member board. And then we could also discuss what the outcome of their conference was as to whether they're willing to move forward with the motion to dismiss with the quorum we have today.
That sounds good. Okay, so we'll take a 10-minute recess. Does that work for you too?
Works for me, yes.
Okay.
Right, thank you.
Back to order. Thank you. Okay, Attorney Carroll.
Are both attorneys are here, okay. So when we went through the process of determining the next member on the electoral board, as I mentioned at the beginning of the hearing, it's done by the most senior trustee. Our review of the clerk's records is that the next 2 most senior trustees, which would be Trustee Reinders and Trustee Consolino, are both candidates in the April election, and therefore they're ineligible to sit. The other 3 remaining trustees were all elected together, so there is no one that's more senior than the other. But what we did is we started going in order on our phone listing. We called Trustee Mason. He was in downtown Chicago, unavailable to get here in short order. Trustee Steilen, who's now on the dais, was nearby, and she was able to come assist and join the electoral board. So the properly constituted electoral board at this time, the final member, and we won't call her trustee anymore, today is member Steilen. She, as the next most senior trustee eligible to sit, will be replacing the former member Fialco on the board. He is sitting on the dais, but he's not a member of this electoral board. He just has all his materials set there, and it's his normal seat for village board meetings. Councilors, we had a chance to talk about, well, we have a fully constituted board now, so I guess the issue on quorum is no longer an issue, correct?
Fair enough. I did talk to my clients on this issue. I mean, they had no objection to a 2-person board, as it turns out. So you seem to have acted before I had a chance to apprise you of that.
Right. Okay. So we're good on Madam Chair, again, we probably should address the issue of the rules, get those out of the way first, if a motion might be appropriate for that.
Is there a motion to adopt the rules for procedure of the municipal hearings electoral board of the Village of Homer, Glen, Illinois?
Madam Chair, I make a motion to accept the rules as presented.
Do we need a second for that then?
I'll second.
Okay.
Is there any questions on the rules? So who calls the roll? Me?
You just, yeah, that's fine.
Clerk,
It's only 3 of you all in favor.
Member
It's fine.
Bilski?
Aye.
Member Steilen?
Aye.
And I will vote aye as well.
So then, Madam Chair, what we have left is counsel for the 14.
Council, do you have a copy of the rules for us?
Yeah, you don't, oh, I thought I gave them to you already. Come on up. Yeah, come on up.
Thank you.
There you go. So, Madam Chair, what we have left was counsel for the 14 candidates and the 1 objector filed a motion yesterday to dismiss the charges based on procedure, and then followed that up with an amended motion today. I spoke with him earlier. My understanding, counsel, the only change in the 2 is just the case numbers. Is that correct?
That's correct.
Okay. So what might be the best way to handle it, Madam Chair, would be to allow Mr. Hurst, who's the movant on that motion.
I've conferred with counsel on that, and I think he has an issue he'd like to address.
Let me get through. Let me get through what I was saying first. So normally, Madam Chair, what would happen is the movant would be allowed to argue his motion. Mr. Abbasi would then be allowed to respond to that, and if a reply is necessary, Mr. Hurst would have that opportunity. But it sounds like Mr. Abbasi might have something he wants to address the chair.
Right, I think, you know, I see in here there's a briefing schedule, and I plan on filing a motion to strike in the case against Nicholas Muller, perhaps on, I guess the first business day is Tuesday. Perhaps I'll prepare a response to the, a written response to the issue on the standing of the board or jurisdiction of the board, and I can file it on Tuesday as well.
So might I understand that you want to have a briefing schedule on the motion to dismiss? Or you?
Or, I mean, I don't have case law in front of me right now to argue it. I can argue it based on the statute, but,
I mean, It's just my opinion that the statute pretty much addresses everything that Mr. Hurst brings up in his motion, but that's up to the two of you. If you want to brief it.
I can argue it. I can argue it today. Yeah. Or unless, are you fine arguing today?
But from what I understand, the motion to dismiss is based off of the timing of the filing, correct?
That's correct.
That is
Which
correct.
you had already shown that the filing was done appropriately and in a timely fashion.
Well, that was my opening statement. However, counsel will be allowed to argue why he disagrees with that, and then Mr. Abbasi will be able to respond to that. Mr. Hurst would reply to his response, and then I would, if the board inquired, give my opinion as well, and then there would be a ruling unless the parties feel it's necessary to brief this, but it's a procedural, not a substantive motion.
I can argue it today. That's fine.
Okay, Mr. Hurst?
Yeah, we can argue that today. That's fine.
So then, Madam Chair, if you want, you could ask Mr. Hurst to proceed with his argument, and we can rule on that today.
Mr. Hurst, proceed.
Thank you, Madam Chair. We filed a amended motion to dismiss on behalf of various candidates. We've raised two issues in the motion to dismiss. Both of them deal with the timing of the clerk's action in giving notice and setting the hearing. First, it's our position that there's no date stamp or anything reflecting, notice on the petition itself. It appears that the objector's petition was received by Homer Glen on November 4th, 2024, and it looks like the notice was issued on November 6th. The election code requires the village to act within 24 hours. It doesn't appear that it did so. The election code also requires notice to all candidates of an objection within 48 hours before the meeting or hearing on the objection. And again, it appears the clerk failed to provide notice within 24 hours. There's also service issues, which we'll address with each candidate, but there are a number of candidates that weren't served.
Was that it?
Yes.
So you would then have Mr. Abbasi respond if he wishes.
So first to service, I forgot the name, sir.
David Hurst.
The council filed an appearance, services.
Would you mind putting the microphone in between the two of you?
We'd argue that any service issues have become moot because the appearance has been filed for all candidates. To the extent that it's argued there's violations with the 10-8 through 10-10 procedure, I'd argue that based on the board's council's timeline given at the beginning, that there aren't any, that all deadlines were complied with, especially considering that in the election code, in Article 1 of the election code, it says any deadline that falls on a state holiday goes to the next day. And also in Article 1 of the election code, it says that November 5th, 2024, as election day is a state holiday. So even if it did, what was supposed to happen on Tuesday happen on Wednesday, it still complies with the election code based on Article 1 of the election code. Additionally, there's nothing in the section 10-8 through 10-10 of the election code that says that even if there were a deviation from the timeline, that the remedy is to dismiss the objections. Whatever the penalty on the board may be, or the members of the board, there's nothing in 10-8 through 10-10 that says if this is missed, then all the objections are dismissed. Given that, the one case I can cite, McNamara versus Oak Lawn Electoral Board, on a different issue, but it says that it's important that even if something appears to not be in compliance with the election code, unless the election code gives a penalty for it, that isn't to be enforced. And in that case, it was a case of two independent candidates running on one petition. The appellate court, the First District Appellate Court, said, well, the electoral code doesn't allow independent candidates to run as a slate. However, they don't provide the remedy of removing them from the ballot if they do. So because of that, we're not removing the ballot. In 10-8 through 10-10, there is no remedy to the candidate of the objections being dismissed for, even if there were a deviation from the timeline, which based on the council for the board's recollection, there wasn't. So for that, I'd ask the motion to be the motion to dismiss to be overruled.
Well, it's
Mr. Hurst, no.
Mr. Hertz?
I get to respond. Thank you. A couple of things. First of all, the dismissal relates to the proceedings. And if the timelines aren't met, the proceedings can't proceed. So council refers to dismissal of the petitions. That may be a secondary consequence, but it's the proceedings that can't proceed if the election code is not followed. And then secondly, there was some reference to my appearance as being a waiver. I think the Illinois Code of Civil Procedure was modified some number of years ago to eliminate special limited appearances. But if you look at the sheet I filled out for the board, I'm here on behalf of various candidates. If a candidate has not been served summons, it's jurisdictional. And I certainly can raise that at any time in the proceedings. If there is no jurisdiction over a candidate, then the board lacks authority to exercise any rulings or remedies with regard to that candidate. And certainly that can be raised, and it may be raised in the future if the candidates aren't served. And certainly bringing a candidate to a proceeding like this does not confer jurisdiction. It's stated in the Code of Civil Procedure what confers jurisdiction. It's service and or some voluntary act by the candidate. And there hasn't been any voluntary acts in this case. So those issues are preserved. I think the motion to dismiss should be granted. The proceedings should be terminated. And where it goes from there, I think, is up to council.
Madam Chair, would you want my opinion?
Yes.
So the first thing I'll address that's, I think, clear is that Mr. Hurst's appearance is not a waiver of his argument. The record should reflect, and it does reflect, that his objections to the process were filed before he filed his appearance. And I agree that special and limited appearance kind of went by the wayside when I still had a full head of hair. So he's right on that. His appearance, in my opinion, is not a waiver of his right to raise this argument. Where I disagree with his opinion strongly is he's mentioned in the Code of Civil Procedure as far as jurisdiction. The election code governs jurisdiction of this electoral board. It does not require actual service. What the election code requires is that the chair issue the call of hearing, which was done, and the chair direct that the call of hearing to be sent via certified mail, which was done, and to attempt service by the Will County Sheriff, which was done. Someone not being served actually is not a jurisdictional bar to the proceedings of this board. As for the process itself, the election code in 10 ILCS 5/10-8 states that the election authority or local election official, which in this case is the village clerk's office, shall note the day and hour upon which objector's petition is filed, and shall not later than 12 noon on the second business day after receipt of the petition transmit by registered mail or receipted personal delivery the certificate of nomination or nomination papers and the original objector's petition to the chair of the proper electoral board designated in section 10(9) hereof. So that would mean the village clerk's office would have had to notify you, Madam Chair, by noon on the second business day, which if election day weren't Tuesday, would have been a Wednesday at noon. But I concur with Mr. Abbasi in that because of the holiday, you could have taken, or the clerk could have taken all the way up until noon on Thursday to transmit these papers to you as the chair of the electoral board. The record shows that even though Tuesday was a holiday, the clerk's office transmitted those papers to you on Tuesday. The code, election code, then goes on to say that once you receive those documents, you have 24 hours to issue a call to the initial electoral board meeting to be held not less than 3 nor more than 5 days after you receive the papers. The record shows, as the notice of call indicates, that those notices of call went out Wednesday. Therefore, you met your obligation under that. The section of the 24 hours does not begin when the clerk or the election official gets the objection filed. It's when they transmit it to you. And the record does indicate that not only did you reach out to the initial 3 members of the electoral board on Tuesday, which was a holiday, but that the call of hearing was actually issued on Wednesday. So well in advance of when you had to have it done, and as a consequence, while I agree with Mr. Hurst that he hasn't waived his argument, I disagree with him on jurisdiction, and I disagree with his motion to dismiss. And you could take that as you will.
May I respond to a couple of remarks you made, counsel?
That's up to the chair. It's not, I mean, you had your argument. She's asking for my opinion, so that's up to the chair.
Sure.
Thank you. I appreciate it. A couple of things. One is certified mail. The concern and the problem with certified mail is on a short timeline such as this. Sure. Can you hear me, Ruth? Better? Good. On a short timeline such as this, where you've got 48 hours to respond, the certified mail is unlikely to get there timely, and I think that's why the election code provides for the Will County Sheriff to go out and actually serve these people. So that's not an if or we can just do either, and you know, it satisfies the requirement. So that's I guess that's my point on that. And then the other issue, and I raised this in my motion, is, you know, there are no timestamps or anything that indicates, you know, when the clerk's, the hour and time and date that the clerk, you know, mailed these things, took these things in. So I think if there is going to be a determination that there was timely action by this board, there needs to be some evidence on which it's based. And I know counsel can't provide that. He's not a witness. So there's got to be some determination about, you know, when the clerk did what she did, I think, to address the motion.
Go ahead.
Yeah, so a couple of things in response to that. Number one, the sheriff did provide, albeit in the form of a kind of a scratch-out sheet, that certainly the sheriff could be questioned on when they attempted to serve each of the candidates. There were also, I didn't mention earlier in the address about social media posts, the deputy clerk did email as many people as she had email addresses for, which is a courtesy above and beyond the two forms of service specified in the election code. And while I don't necessarily disagree with the spirit of counsel's argument, the election code stands for what it stands for. It requires those two attempts at service, and both were had. Now, I know Trustee Fialco mentioned he just got his certified mail this morning, but you know, he also admitted he was out of town. The election code does not specify what happens if the U.S. Postal Service doesn't get the green card back in time, or the person refuses to accept the certified mail. It's silent as to that. The election code is silent as to what happens if someone dodges service from the sheriff or isn't home. But because this is an election where a candidate presents themselves for election and submits nominating papers, and all the case law says time is of the essence, the legislature provided for these two methods of service. And also, I will point, if the chair is interested, the deputy clerk who did most of these steps since the clerk, as a member of the electoral board, is here today, and she's available if the board wanted to question her or allow her to be questioned by counsel for the parties.
Is that your recommendation to bring?
Well, I mean, my understanding is there are, in addition to, this is a document from the sheriff, similar to what we would call certificate of service in a civil case. She was keeping the record on all of those because her boss, the elected clerk, was a member of the electoral board. So it certainly couldn't hurt if you wanted to allow her to be briefly examined by the attorneys. Is that something the two of you would be interested in?
I would.
Okay.
I will go get the clerk.
Okay, I'll get her. Oh, I can't get through the door.
I will.
Okay.
I mean, the village.
Deputy Clerk Marcotte will be arriving in just a moment. She's coming through the back door. No, can I?
Where should I go?
Would you like to sit right here at one of the microphones? So,
You can sit as close to me as possible. Oh, okay.
Madam Chair, are we back on?
sorry.
Madam Chair, the election code does allow the board to swear in witnesses. You can also have a court reporter here who's capable of doing this, whatever you prefer.
Let's swear Ms. Marcotte in. Deputy Clerk.
Court reporter?
Or court reporter, I'm
Okay.
sorry.
Please raise your right hand. Do you sound swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you.
Mr. Hertz?
Thank you. Can you state your name, please?
Yes, it is Gina Marcotte.
And Ms. Marquette, what do you do for a living?
I am a deputy clerk for the Village of Homer Glen.
How long have you been the deputy clerk for the Village of Homer Glen?
Oh, gosh, about 8 years.
And what are your duties and responsibilities as deputy clerk as it relates to receiving objectors' petitions in election matters?
Okay, so when I receive the objection petitions or any objection, the person will submit it to me. I have a receipt that I fill out, which I also give a copy to the objector. And on the receipt, it states their name, the person's name that they're, or the petition that they're objecting, that person's name, the date, and the time.
Do you have any of the, do you keep a copy of the receipt?
Yes, I do.
Okay, do you have any of those with you this afternoon?
I believe the mayor has them,
Okay.
or she has a copy of them, because once I got all the objections, what I did is I made copies of all of that, and then I made copies of the petitions. I gave that to the mayor, and I believe it was, so when I got the objections, it was probably around, I think I got one like 3 in the afternoon. The other one came in a little bit later, like around 3:30. So it was the very next day, I believe it was around 10 o'clock, that I gave them all to the mayor. I also have her sign a form with exactly what I gave to her, and I have her sign, date it, and timestamp it as well.
Okay, so you're getting a little ahead of me here. You indicated that you generate a receipt.
Yes.
When they finish my question. When
Sorry.
the objection comes in, you generate a receipt, is that
Yes.
correct? Okay. And you said you gave a copy of the receipt to whom?
So I give a copy of the receipt to the objector, so they have it for their records, and then I keep a copy for my records.
Okay, and did you make another copy of your records for the mayor, or did
Correct.
she get? Or did she
No,
get
I
your
make
copy?
a copy, I keep all the originals, and then I make a copy for the mayor.
Okay, and I have some specific questions about information on that receipt. Would it be beneficial if you saw
Yes.
the mayor's copy?
I'm sorry.
Madam Mayor, I'd ask that if you have a copy of this document that's been given you, these receipts, could
There's a
you?
document for each one, they're all the same. There's a receipt for each one, they're all the same.
You know what, she just testified, though, that they were received at different times.
Right.
So they may not all be the same.
Well, I mean, the receipt.
Well, the first 15, or the first 14 that I received to me, because he handed them to me all at once, so I put the exact time on all of those.
So they were given to you as a batch, is that correct?
Yes, he gave them to me in one batch.
Okay. I understood you to say you received 3 objections and then another group of objections around 3:30
No,
that
I
afternoon.
received, so around 3 o'clock, I received 14 objections. I'm sorry, so it was 14 objections at once, and then it was around 3:30 that I received one specific objection.
Okay. The 14 objections are the ones that I'm going to be focusing on.
Okay.
In my questioning here. So with regard to the 14 objections, what day did you receive those?
So it was on the final day that I was to receive objections, so that had to have been Monday, which was November 4th, I believe.
If you looked at the receipt, would that refresh your recollection? You seem hesitant.
Can I see it? I'm sorry.
And I'd ask that all of the receipts be given to her, so we're not,
These are the originals, but.
I'm sure she can be trusted with.
Yep.
Thank you.
Okay, do you recognize those documents?
Yes, so it was November 4th at 3:35.
And that's when you received the
The 14.
14 petitions, correct?
Yes, and I received them from a Mr. Piri. Abbasi was the one who handed them to me.
And is that the same Mr. Abbasi that's standing right next to me?
Yes.
Okay. Very good. All right. What's the next thing you did after you generated those receipts?
Okay, so after I generated the receipts, I went back and I made a copy of all of the receipts for Mr. Abbasi so he would have it as well.
Okay. So he got a copy of the receipt, and then what did you do with the petitions themselves?
So the objections?
Yes, I'm sorry, the objections. Thank you.
So the objections get put in a folder together, and then they get locked in a fireproof cabinet in my office. And then because it was late in the afternoon, because I did the lottery for the petitioners at 4 o'clock, so it was the very next day that I made the copies for the mayor.
Okay. So after making the copies for the mayor, so you came back in, let's say, November 5th.
Correct.
Were you working that day?
Yes, I was.
Okay. And what did you do with the objections, if anything, on November 5th?
So I made copies, well, I scanned them in, so that way I could have a scanned copy. Then I made copies of all the objections. Actually, I made a few copies. So the first set of copies I made were for the mayor. And then the next set of copies that I made were to put together for all the candidates who had the objections against them.
May I approach the witness?
Yes.
Yes. But I did not give them a copy of this. So they did not receive a copy of that.
Now, when you say this, you're referring to the...
Just the receipt.
Okay.
That was the only thing I did not give them. So they got a copy of the call,
Who is them?
the petitioners, or the people that had the objections filed against them,
The candidates.
the candidates,
Who generates the call for hearing?
the attorney.
And then what do you do with the call for hearing?
I scanned them in, and then I made copies for the electoral board members, and I made copies for all of the candidates who had the call hearings for.
Are the call for hearing, and that's this document right here?
Correct.
That's what we're talking about. Is this document disseminated out of your office?
It is
somewhere?
not.
Okay. Is there a notice of some type that is issued by your office to the candidates?
That was no, so the only thing that I gave them was that call hearing and a copy of the objection
So when you say them, you're referring to
to
the
the candidates, sorry.
And when you say you gave to them, you didn't actually hand them to the candidates, did you?
Some of them, yes, because a few of them were served. And then when the lieutenant came in and told me that there was a few that he could not reach.
Hold you right there. I'm
Okay.
going back to this witness testifying to any hearsay statements that a police officer may have made to her.
Well, go ahead.
That's up to you. Unless you-
I mean, I'm not,
You're allowed to hear hearsay, but if it's the type that's reasonably reliable, so it's up to you. If you want to let her testify. And she may not be testifying to the hearsay for the truth of the matter to be asserted, just to say what she did next, which would not be hearsay.
okay.
So you can say overruled.
Sustain or overrule?
Yeah.
So I'm sorry, I'm new to this. So he's basically asking me to not allow her to, or not allow hearsay?
So if you want to hear what she has to say based on what I just told you, you could say overruled.
Overruled.
You stated that the police officer told you that they had served somebody, is that correct?
Yes, so
What do you do next?
okay, so I had given him a list that morning,
Him is,
the lieutenant,
do you know his name?
Piazza,
Piazza?
yes.
Okay. And what did you do? You gave him what now?
So after I made copies of all the call hearings and copies of the objections for each of the candidates, I did two things with them. So I made two sets of copies. I made a set of one set that I sent to each candidate, certified mail, which I sent to the post office that day. The other set I gave to the Lieutenant Piazza to serve the candidates. So I gave him a list with their names and addresses.
Okay, let's back up a little bit. You said you issued something by certified mail, is that correct?
Correct.
What did you issue by certified mail?
So I issued a copy of the call hearing and a copy of the objections.
Okay, and when you say you issued it by certified mail, was that generated from your office here in
Correct.
in the township?
Correct.
Okay, and who did you mail those to?
So I mailed them to each of the candidates, and then one of the candidates, I also mailed her objection that she had for a candidate.
And
So
when did that mailing go out?
So it went out that Wednesday afternoon.
What date? What is the date that was mailed out?
So if Monday was the 4th, so the 6th of November. Right, 4th, 5th, 6th, yes.
Was the township office open on the 5th?
You mean was the Village of Homer
The
Glen
Village of
open?
Homer Glen,
Yes,
thank
we
you.
were open.
Were you at work that day?
Yes, I was.
Do you know if there was mail service that day?
He actually came in before I could hand him the letters, so I drove it to the Lockport post office myself and dropped them off.
I'm talking about on the 5th, not the 6th. Was there mail service on the 5th?
That I don't recall.
So you missed the mailman on the 6th, is that correct?
Correct.
And you said you drove it someplace? What did you do?
I drove it to Lockport post office. It was around 2 o'clock in the afternoon.
And when you say you drove it, what are you referring to? What is the it?
So I drove the letters with the call letters and the copies of the objections to each of the candidates to the post office.
Okay. And then you indicated that you spoke to Officer Piazza at some point.
Yes.
What day did you speak with Officer Piazza?
When he came back in on Wednesday afternoon, so it was after I came back from the post office, and the lieutenant told me, he gave me the list of the people that he was able to serve and the people that were not home.
What did you give to Officer Piazza when he came and met with you?
In the morning?
Yes.
I gave him letters that were addressed to the candidates, and in those letters were the call hearings and a copy of their objections.
And that's the physical document, the objection?
Correct.
The objector's petition, correct?
Correct.
Okay. And so you gave all 14 of those to the police officer, correct?
15.
15, thank you.
Yes.
And what day was that?
That was on Wednesday.
So that would be the 6th, is that correct?
Correct.
And then after you gave those to him, when did you see him again?
So I saw him when I got back from the post office, so it must have been a little after 2 o'clock.
And was that on the 6th or 7th?
No, the 6th.
So am I correct that you gave those petitions and documents to him the morning of the 6th?
Correct.
Okay, and then you saw him the afternoon of the 6th.
Correct.
And did he report back to you on his success or lack thereof with regard to service?
Correct.
All right. When you went to the Lockport post office, did you use your personal vehicle or a company vehicle for that?
I used my personal vehicle.
Is there a process for setting the hearing date on the objections?
To my understanding, I'd have to look at the book, but yes, I'm not quite sure about the hearing dates, but I do know the process of when the last day is that I'm allowed to receive objections, the time frame when I have to turn them into the mayor, since she is the chair of the electoral board, and the time frame when she has to notify the candidates.
So how were the hearing dates set in this case?
That was between the attorney and the chair.
So you had nothing to do with that?
Other than posting the agenda, making sure it was posted in the time frame, yes.
When was the hearing posted? And I'm referring to the hearing for the 14 petitions that we're here on today.
It was posted, and I can even grab my phone and show you because I get notification. It was posted exactly at 2:15 on Wednesday.
And that is the 6th, is that correct?
Correct.
Did somebody ask you to take these documents to the post office using your personal vehicle?
No, they did not. I could have taken the work, because we do have a work vehicle, which I could have taken, but I chose to take my personal vehicle myself. I was trying to rush to make sure that those letters went out as quickly as possible. And I was trying to make it in time for when the mailman came to our office, but because I missed him, I decided to drive over there myself.
Okay. I don't have any further questions. Let's switch sides. That way they'll be able to hear. Oh, here.
And when again was it you went to the post office?
It was around 2 o'clock on Wednesday,
Okay.
or I got back around 2 o'clock.
Okay. There's no further questions. I think we covered the process.
Okay. Do the board members have any additional questions?
I can't know.
Is there a motion to sustain or reject the motion to dismiss?
Madam Chair,
Yeah.
I want to allow counsel, if he wishes to have
Oh.
a final argument on that before you take a vote.
Attorney Hertz?
Thank you.
Thank you.
Based on the witness's testimony, it appears that the objections were received on November 4th, 2024, and it appears that the notices went out more than 24 hours later. In fact, they were mailed on the 6th, and it sounds like the clerk used her personal vehicle, and she explained that there was mail service on the 5th, but they just didn't get mailed out that day. They went out the 6th. So I would, again, reiterate that this is not timely, and the motion to dismiss should be granted.
Mr. Abbasi?
I'll say the election code says, one, it says the second business day. Two, Tuesday was not a business day under the election code. It's the election code, Article 1 specifically says November 5th, 2024, as the general election day for 2024 is not a business day for purposes of computing things under the election code.
Mr. Hertz? Or Attorney Hertz?
Yeah, no further argument.
Madam Chair?
Yes.
Just for procedure, so now you're ruling on a motion. This wouldn't necessarily be a motion of anyone from the board. The board members are allowed to ask me as the electoral board attorney any questions if you're at all up in the air about the arguments of the two counsels for this case. I'd be happy to answer any questions you may have. And then what you would do is you would just take a vote of each of the three members to either sustain the motion to dismiss, in which case this case is over, or to reject or overrule the motion to dismiss, in which case we would then proceed to the next stages and move forward with these hearings. So I'm available if the board has any questions for me.
Does the members have any questions for the attorney?
Just clarifying the second business day.
So, as mentioned, I think it's my opinion that the movant, in this case Mr. Hurst, is conflating the 24 hours that the chair has to send out the call with the requirement of the election official, in this case, the village clerk. The village clerk, even if you didn't count Tuesday as a holiday, a legal holiday, had until noon on Wednesday to transmit the objections to the chair or the mayor, and then the mayor had 24 hours to issue the call. If you count the holiday, then the clerk had till noon on Thursday to transmit the objections to the chair, and the chair would then have 24 hours to issue the call. Whether Deputy Clerk Marcotte was working or not, whether the village hall was open or not, whether the post office was delivering mail or not, is not relevant to the state statutes on holidays. If Election Day is a state holiday, which it is, it's a holiday. But regardless, if you look at the timetable allowed in the election code for the clerk's office to transmit the objections to the chair of the electoral board, the clerk's office was well within that time period of transmitting. Furthermore, based on what you heard from Deputy Clerk Marcotte, the calls were generated, issued. They were issued by the chair on Wednesday within the 24-hour period that was discussed. Whether Clerk Marcotte met the mailman here or didn't, there's no requirement in the code that the certified mail go out within the 24 hours, just that the issuance of the call be had, which it was. And there's no requirement that the sheriff get service within 24 hours, just that service was transmitted to the sheriff, which it was. So based on that, if you're talking about the business day and the timing on it, it's my opinion that the process in this matter, we're not talking about the objections yet, so we're not talking about the merits of the signatures or anything else, but the process in this matter, it's my opinion, it was done properly.
May I speak to that?
Sure. You're the chair.
Well, I mean, I received from the clerk, the objections were made on the 4th. I received them on Election Day, the 5th. I notified the previous electoral board that same day via email and phone, asking when this meeting was to be had. That same day, the previous electoral board had responded and called for this date and this time. The lieutenant has a documentation here of who he served and when, which all still falls within 24 hours. So I'm confused as to the objection. Not that I'm confused, I just don't understand the argument based on the 24 hours, because it's done way less than. So that's my opinion.
Madam Chair, may I clarify something too? And I agree with Mr. Hurst. Anything I say is not evidence. I'm giving you some clarification here because the witness testified to the call being issued between you and your board's attorney, which is me. I will note, I'm looking at my laptop right now, the call was transmitted to the deputy clerk at 11:04 on Tuesday, 11:04 p.m., and that was per your direction. So everything else we're talking about, the sending things via certified mail and giving them to Lieutenant Piazza for service was done, that's not within the 24 hours. The issuance of the call is what's important.
Makes sense.
And that was, I transmitted that to Gina Marcotte at 11:04 p.m. on Tuesday, all 15.
Okay, is there any additional questions from the members? So do I call for a motion to reject?
No, you would just individually, one by one, ask whether to sustain the motion to dismiss or to overrule it.
Member Stylin, would you like to reject the motion to dismiss or sustain the motion?
So the term, reject.
Member Bilski?
Reject.
I too reject. Okay.
Can I get a copy of the police officer's notes that you've referred to a couple of times?
Sure.
Just, I don't need it right this second, but just sometime.
We'll make a
before
copy. It's
we-
right here. I'll make a copy for you
Thank you.
before the end of the day.
And council, it's our intention to also issue a written ruling, even though the electoral board has, and I'll get that to you within a business day, so, on the motion to dismiss.
Okay, so now are we doing the
Well, I know they were going to confer, councils were going to confer when we took our recess about what their next steps would be.
Right, so on the the Mueller case, which I believe is 12, I plan on filing a motion to strike and dismiss. The basis being that even if every objection was sustained, Mr. Mueller would still have above 60 signatures, which is the minimum. And then I'm not sure if council would be filing a motion to strike or dismiss certain allegations within the 14 objections where he's representing the candidates. I believe since Monday's a holiday, would the motion, the initial motions perhaps be filed on Tuesday? And then a response, what do you think, Ruth? Or I guess, like, if you file the initial one, like for the 14, because you're not on the 15th, are you?
No, the 15th's a Friday.
Oh, I mean, you're not on the case, you're not defending or you're not representing the objector in the other case, right?
We will be
Oh,
representing the
you will
objector.
be, okay. So,
I'm sorry,
We'll respond to your motion.
they're having a
for-
discussion, I
They're
can't.
conferring right now, yeah.
Yeah, I'm sorry. We
That's right.
should have cleared all this ahead of time. So I understand he wants to file, why don't we do this? Why don't we give me time to file my objection, give him time to file his objections, the substantive objections that we may have to the specific allegations, and then just a short time to reply and respond, and then a hearing date on those.
so perhaps, since the next business day is Tuesday, we'll file our motions by Tuesday, and then by Thursday?
You mean the 12th?
Yeah, the 12th.
I have 2 hearings on the 12th and a meeting at 7 o'clock. So there's and the 11th, I'm booked all day. I mean, I could file something by the 14th. Sorry.
I mean, that's fine with me.
I'm so busy, it's ridiculous.
Like, I'm perhaps the 14th, and then Monday, the 18th for responses?
Let's make it the 19th.
Would the 14th for motions and the 19th for responses,
Will there be a reply date beyond that?
2 days later, would that work for you?
Sure, let's make it the 22nd.
I guess the 22nd. And I'll look through the rules. Is there a section on subpoenas? Is there a deadline for subpoenas within the rules or requests?
I vote,
I don't know if there's a deadline, but there is a provision for subpoenas to be issued. And then let me let you know, too, council, on the motions you're going to file, the rules that they adopted, have me be the basic clerk. So any of your filings would be emailed to me, and I know I've emailed with both of your offices, so you should have my email. If you don't, come on up and see me, and I'll take care of that.
Yeah, we'll do that. We'll notice each other as well.
Yeah, let me just double check on subpoenas. I know it's in there. Here we go.
I think it's number 10.
Yep.
At 10, so
And then can we get a hearing?
They must be requested within 5 business days of the initial hearing unless such time is extended for a good cause shown by the electoral board.
So I think we can stick with that deadline too.
I'd prefer we do it within 5 days because they won't be reconvening again before then, so.
Okay.
Is that fair to both of you?
That's fair, yes.
Can we come back the week of the 25th?
So if each of you, the board members, can check the calendar for the 25th.
That's Thanksgiving week, so.
It is.
Just make sure you're in town.
Yeah.
I'm available.
I'll be in town, so.
So the chair is available, I'm available.
So I guess preferably earlier in the week.
Yeah, 26th, Tuesday.
That works for me.
What time of day would the attorneys prefer to do it?
Well, I'm in court every morning, so
Yeah,
sometime after.
You and me both.
After 10 o'clock,
Yeah,
maybe afternoon,
maybe 1 o'clock. Would that work?
or 2 o'clock's even better.
Member Stone, can you do 1 o'clock on the 25th?
Council suggested 2 o'clock would be better for him.
I'm sorry, one person to speak at a time.
Council suggested 2 o'clock would be better for him. It works.
2 o'clock?
Yeah, any time in the afternoon works for me, so.
Is that on the 26th or 25th?
They said the
25th.
25th, which is a Monday.
Or actually, the 26th.
26th.
Oh, no, the
26th.
26th, which is a Tuesday, at 2 o'clock.
I've got to be the hearing officer for the Village of Homer Glen at 3 o'clock. But I can probably get that done in an hour. Yeah, usually we're done in an hour.
Would 1 o'clock, would that give you enough time?
Well, you tell me, what do you anticipate doing on the 26th?
Probably arguing 3 motions.
Yeah, arguing the motions. I mean, perhaps if the subpoenas get served, I mean, we might have evidence.
Well, here's the thing, if we're not done,
If we do have subpoenas.
if we're not done, we could pause it, and I could, it's going to be in the same room, I have to do the hearings. I'm covering for one of my associates. She's on vacation that week.
Let's do it at 1 o'clock. That'll at least give us 2 hours.
All right, 11:26, 1 o'clock, is that agreeable to everyone on the board? Okay.
And let me, is there, and for the, when the motions are due, I guess we should specify 5 PM is like on the day when it's due, or should it be 6 PM? Do you have a preference, or like
6 p.m. would probably be the most reasonable.
Okay, so let's say on the 14th, 19th, 22nd, 6 PM will be the filing deadline.
So what I will do is I will circulate to the board members a draft order of today's proceedings indicating that the motion to dismiss was denied, and that motions in this matter, substantive motions shall be filed by 6 p.m. on November 14th, responses on November 19th, replies by November 22nd, and that this board will reconvene November 26th at 1 p.m., same location. Does that sound, have I accurately set that forth?
That matches my notes.
That sounds fine.
Okay, and then for members of the public, when you're reconvening a meeting or a hearing, you don't have to issue a new agenda or a new notice of hearing because you're here today. Now, it's up to the clerk's office and the mayor whether they want to still put it on the village website, but it's not the same as when you're doing your first meeting. When you're continuing a proceeding, the Open Meetings Act allows, as long as that date and time is set forth at the end of your hearing, which it just was, it will not be re-noticed. So for those of you that wish to attend, it would be November 26th at 1 p.m.
Okay, so is that it?
Now we do a motion to adjourn, unless, anything else, Counselor, or no?
No, sir.
Is there a motion to adjourn?
And thank you, Madam Chair.
I
You're
so move.
welcome. Member Stylen?
I second.
Member Bilski, meeting's adjourned.